Hi, and welcome to another edition of the Trustcast Show. And we're really happy to have with us today Dan Hayes. Welcome to the show, Dan.
Thanks, Zane. I'm glad to be here, and I'm looking forward to it.
So, Dan spent 13 years inside the SEC as a trial attorney, actually building the cases that companies and executives dread receiving. And now he's on the other side of the table, defending them. Dan, you prosecuted the SEC's case against Volkswagen. And I said earlier, that's actually really an interesting case. For me personally, I found that very interesting for defrauding U.S. bond investors during the emissions scandal. What was it like to be on the government side of that kind of high stakes front page matter?
It was exciting. It was great. I really appreciated that the trust the SEC put in me to handle that. But I mean, it was great because the judge was former Supreme Court Justice Stephen Breyer's brother, Charles Breyer, out in San Francisco, and we had great lawyers on the other side defending Volkswagen and Martin Winterkorn, the CEO, and I had great lawyers at some of the best at the SEC assisting on the case, working with me on it. So it got a lot of press, and it was just a lot of fun. I mean, it was a great case. We believed in it. It was fun too.
It was fascinating, and you wouldn't think a corporation at that level would do something so underhanded. It was hard to believe.
It was hard to believe. Except the one thing I'll say I learned at the SEC almost from day one when I got there, the amount of stuff that you think you wouldn't believe actually happens on a daily basis. I mean, there's just a lot of stuff going on that at first blush you're looking at this and saying, can this absolutely be true? And some of my colleagues, when I was new there, would say, "Oh, you're that's so cute. You're so naive," because people would engage in all manner of crazy types of fraud, and you would see it on a daily basis. And you could only
From big companies.
big companies, yeah. I mean, before like Madoff, there was another big Ponzi scheme case, a gentleman by the name of Tom Petters out of Minnesota, and nobody even remembers Tom Petters really today because Madoff back in 2000, mid 2009, 10 or whatever when it came out, he eclipsed everything. But before Madoff, the Petters Ponzi scheme was billions of dollars, and he was running these big companies. And so it's amazing what goes on.
So you spent 13 years at the SEC. What was the impetus that made you decide, you know what, I think I need to go the other side? Was there something that kind of stuck out at you?
My age really was the first thing that, I was getting into my 50s and I thought, well, I've had a great career here. I loved it. It was the best job I ever had. Probably the best job I ever will have. I easily could have stayed, but I thought to myself, if I'm going to do something else, now's the time because, I frankly, finding another employer, whether it's a firm or in the private sector, in your mid to late 50s, nobody wants to hire some guy to come and coast for 5, 6, 7 years until they retire. So I felt like
Hmm.
the time was my early 50s. It was time to go if I was going to go. And kids in college and that sort of thing, it was, I think it was time to switch sides, so to speak.
So tell me a little bit about Venable, which is the firm that you ended up at.
Yeah, so
Just a
it
brief
was.
thumbnail.
Yeah, it was. It's a great firm. It's up around 900 lawyers now, with based out of D.C., and they've got lawyer or offices kind of around the country now. The Chicago office had just opened up maybe a few years before I started looking into moving back into private practice from the SEC, and just so happens that um, somebody I knew, my kids had gone to school with him, with his kids, and I had actually worked with him a little bit when I was a summer associate at Baker and McKenzie back many, many years ago. a guy by the name Mike Morkin, he had moved from Baker to, after 30 some years at Baker, where he was the managing partner of the Chicago office, moved to Venable. And so I reached out to him to just talk to him about it. And one thing left to another. And really the things that sold me on this firm, and I knew about Venable. It's a great firm. It's been around for 125 years. It's great lawyers. But that's a lot of big firms are like that. And he couldn't stop talking about the people, how great the people here were. The culture was here. And what he said to me that really I think was the clincher, Zane, to me was, he's like, look, you've been doing this almost 30 years, grinding away. It's like, we're building something in Chicago. The chairman of the firm, Stu Ingus, when I came over to Venable, said, look, Mike, I want you to help build out Chicago, and I want you to go find the people you want to work with and go hire them. And he said, Dan, I want you to help me do that here in Chicago. So let's have fun. And that's what we've done. I think I was the 20th lawyer in the Chicago office almost 3 years ago, and now we've got close to 40. And so it's just been fun. We've been hiring great people, and it's just a different experience than just trying cases and building cases and being a lawyer. It's building an office as part of a larger firm, which most lawyers don't get to do. It's been a lot of fun.
So let me ask you some questions from the perspective of what your clients might ask you. So the SEC contacts my company. What do I do in the first 24 hours?
You reach out to a lawyer. You find a lawyer that's experienced in handling SEC matters, and don't panic, because the SEC reaches out to lots of companies for all sorts of different reasons, most of which really have nothing to do with the company doing anything wrong. They could be just looking for information. They could be conducting a routine examination. But bottom line, I don't think there's an instant where the SEC reaches out where I'm not at least recommending they've got to reach out to in-house counsel or outside counsel experienced in SEC matters.
So is there any difference between receiving a subpoena and just an informal request for documents? Does it matter which one I got?
Yeah, it does. The subpoena is compulsory. You got to respond to the subpoena. The informal request is just that. It's an informal request, and it's much better to get one of those because it's easier to negotiate with the staff, the SEC, about what you're going to produce, when you're going to produce it, if it's an informal request. And in this current administration, under the current chair Atkins, they've been doing more informal requests up front before they really start their kind of investigatory process. When you get a subpoena from the SEC, it means they've actually officially opened an investigation. So the commission has actually taken some formal step based on some facts that the staff has presented to them and said, okay, we see something fishy going on. We'd like to open a formal investigation so we can serve subpoenas. Without a formal investigation being opened or ordered by the commission, they cannot serve a subpoena.
So my lawyer told me don't talk to the SEC without counsel. What does that mean, ever? I mean, how does that work?
Yeah,
Without the counsel there, or?
Well, I mean, I think it really depends on the context. I think that's 95% true, right? I mean, sometimes when I was on the SEC side and I'd call people up just to get some information, basic information from them, I felt, I was sheepish because I'm like, oh man, I'm going to call this person up. I'm going to identify myself as Dan Hayes from the SEC, and they're going to go into a slow panic, over the call. So a lot of times I had to leave a message on a voicemail or with an assistant or whatever. And so, most of the time it's just to, most of the time you want a lawyer present. And it's perfectly acceptable. And everybody on the SEC that calls out, reaches out, would understand you saying, you know what, Dan, I'll call you back, but I'd like to talk to my lawyer first. And that's totally fine and acceptable. And in most instances, that's what you should do.
So if the SEC is already investigating, is there anything that I can do to influence that outcome, as the investigation goes along?
Yeah, I mean, there's a lot of things you could do. Really, you need to understand. You try to understand as best as possible what's happening, and what they're investigating, and what they're interested in. But a lot of times you can, and I think this is kind of part of the new Chair Atkins kind of thought process when he went to the informal order process, or the informal document requests and requests for information rather than just starting out serving subpoenas, was, look, a lot of times that the respondent or the person the SEC is reaching out to with their lawyer can help us get to the conclusion faster than we would get to it in some kind of adversarial process where the SEC sends a broad document request or a subpoena, and you produce documents. You say, look, if you can help me, SEC, Mr. or Mrs. SEC person, understand what you're looking for and why you want it and what you're investigating, I can maybe just give it to you, yeah, or tell you which witness to go get it. We can, to get it from. So, but the only way you're going to be able to do that really is if you've spoken with your lawyer and you've kind of come up with a plan with your lawyer, and your lawyer and you are confident that, yeah, okay, this really isn't about us. Or if it even is about us, we've got a great story, we've got no issues here, and let's just nip this in the bud now, rather than spending a bunch of money in 6 months, 9 months, whatever, fighting over subpoenas, all to get to a result that hopefully is just going to be the SEC dropping the matter. So a lot of times it's cooperation with them and reaching out, and lawyers that know and have the ability to communicate with people internally at the SEC can really move the process along.
So it can actually be helpful to cooperate rather than obstructing. So do you think your experience as an SEC lawyer gives you some insight in that process?
Yeah, so without a doubt. I know from 13 plus years working there and working on investigations and cases, what they're looking for. When they ask for X, Y, and Z, I know why they're asking for X, Y, and Z. And then the relationships. Obviously, I can feel like I can call certain people and get them on the phone, and we can have a nice, cordial, frank conversation with each other. Hopefully, I've built up some trust internally with those folks, and so I think that helps as well. So. Certainly, anytime you have an SEC matter, to the extent that you can find somebody and hire a lawyer that has experience working with the SEC and knows the people in the SEC, not that they're going to do favors for you,
Right.
but, it's that dialogue and that communication and trust that's been built up over time that I think certainly can work to the client's advantage 9 times out of 10.
So what's a Wells notice? And if I get one, is it already too late to change the outcome?
No. So a Wells notice is a formal written notification from the SEC that the SEC staff, that they're going to recommend, they plan to recommend charges against you to the SEC. And it's a very summary document. It's very short, just says, we plan to recommend charging you with violations of X, Y, and Z. And once you get that Wells notice, the SEC gives you time to respond, whether in writing or however you want to do it. Sometimes request a meeting with senior officials, sometimes both. And you can really, you can change their mind. I mean, I've seen it. I've been on both sides of it, where the Wells notice actually does what it's intended to do, which is really give the client or the party receiving it an opportunity to say, hey, wait a second, you've got this wrong, or even if you've gotten it right, mostly right, you shouldn't bring a case here, and here's why. This is not every technical violation deserves to be an SEC enforcement matter. So yes, it's not too late, and you can change the SEC's mind.
What's the most costly mistake companies make in the early stages of an SEC investigation?
Not reaching out to counsel, not obtaining counsel that that knows, kind of is experienced in SEC matter. That in blowing off, just assuming that I got a subpoena, we're going to ignore it, or we're going to the SEC will just go away. Not being upfront and candid and honest with the SEC. If they're looking at you and they think that there may be securities law violations, and you blow them off, that only reinforces in their mind that they're on the right track. If you mislead them, that reinforces their, in their mind that they're on the right track. If you've got real exposure and liability, the best thing you can do is to work with a counsel to figure out, all right, how best do we resolve this? Because maybe if we resolve it early without trying to mislead them or obstruct them, we'll get the best possible deal that's on the table. That they'll make it. We can reach a settlement that allows us to, put this matter behind us and move forward. That's harder to do the longer you go obstructing and trying to mislead.
So the one thing that frustrates the general public about these SEC matters is when they see some sort of wrongdoing and the company gets slapped with some big fine, and but then the perps, for lack of a better word, actually they get off. They're not criminally prosecuted, and the public, I know, gets really frustrated with the idea that guy did this horrible thing and they profited, and the company, they had to pay a bunch of money, but he got off.
Yeah.
Can you kind of comment on that?
Yeah, I do. I mean, look, it's frustrating. It's the public's right to be frustrated by it. I mean, I think there's a few things to point out. One is, for folks, a lot of folks, I think, are confused and think the SEC can put people in jail, that it has criminal enforcement authority. It doesn't. All the SEC can really do is get fines, kick people out of the industry, some other tangential remedies. But they don't put people in jail. That's the U.S. Attorney's Office, and the SEC's burden is lower. That's a regular kind of court case, and more likely than not, the SEC has to prove that the person did what they're charged with. With the criminal authorities, they have to prove it beyond a reasonable doubt, which is much higher. So it's much harder to do. I think for the SEC's perspective for many years was that if we charged a corporation with if the SEC charged a corporation with wrongdoing, they has to also charge an individual, because the corporation didn't act on its own. Some individual acted for the corporation, and so historically, and mostly, and not always now, but mostly when the corporation was charged, there was an individual charged along with it. Now, frequently, and I think this gets to what you're getting at, that individual wasn't the senior official. Wasn't, it might have been more of a mid-level manager as opposed to the CEO or some senior officer of the company, who everybody kind of feels they're the ones calling the shots, they're the ones responsible. But when it's the managers and the line folks of a company out doing the work, sending the emails, putting the documents together, it's a hard case to prove, unless you've got cooperators, that the CEO or COO or somebody above them was giving the instructions to do it, or knew it was going on and didn't stop it. Because there's often not emails directly between the two, and unless people internally are cooperating and say they had those conversations with the senior officials, it's harder to pursue cases against them. But the public's right to be frustrated with it.
Is electronic discovery quite a bit different now than it was like even 5 years ago? How does that?
Yeah. I mean, it's all electronic now. I mean, when I first started in private practice almost 30 years ago, literally I was in a warehouse in South Bend, Indiana, looking through boxes of documents and stuff, and that just doesn't happen anymore. Pretty much everything, almost, it's almost 99% electronic. Emails. We hardly get mail anymore. Regular post office mail. So the nice thing about it is it's expanded the volume of material. That's not the nice thing about it, but one, we've expanded immensely, but multiple magnitudes, of the amount of information that's collected in discovery nowadays. But every firm now, every big firm, and and a lot of smaller firms have kind of data management, people, IT people that can help process and gather that information, and we all use consultants, outside consultants, to help gather and process that information. And once it's electronic, it's so much easier to review. And copy and maintain and sort and identify what's important and not important. And you don't have to sit in 40-degree cold warehouses in South Bend, Indiana for 2 weeks. So it's easier to search and manage, especially now with AI that can assist. But it's exponentially increased the volume of information that's available.
So what does it actually mean to cooperate with the SEC, and is cooperation always the right move? Let's say for one of your clients.
Go ahead, Zane. I'm sorry.
No, I was just using an example just for one of your clients, for example, depending on the situation.
It's not always the right move, and it's so cooperation really, from the SEC's perspective, is doing more than what you're required to do. So if you get a subpoena and you respond to the subpoena in a timely manner and give them everything you want, that's not cooperation. That's just complying with the law in their eyes. Cooperation is really basically coming in and help them break the case open. Is basically admitting, to the extent that you need to admit that you did wrongdoing, come in and candidly admitting you're wrong, take responsibility for actions. Or if you've got information that can help them expand their case and bring in other people, responsible people, that's cooperation. It's kind of what you see on TV is the cooperating witnesses and that sort of thing. And they've gotten better at it. For a long time while I was there, we had these cooperation programs, but they weren't really televised. They weren't really promoted or marketed, and defense counsel was like, what do I get out of this? And the SEC wasn't great at telling people what they're going to get if they cooperate. Well, just wait till the end of the case and we'll tell you then. We promise we'll reward you. Well, that's, for a lawyer advising his client, that's not good enough. And so there was a lot less cooperation. Mm-hmm. And under the last administration, under Chair Gensler and certain his enforcement directors, Gurbir Grewal, and even now, the SEC has really been, I think, put some more finer points on kind of upfront. Here are what the benefits to cooperation are going to be if you cooperate, which has, I think, inured both to the clients and my client's benefit, as well as the SEC's benefit, because more people are willing to cooperate. But it's not always, the right case to cooperate. A lot of times it's, you want to put the SEC to their proof. Can they really make out the case that they think they can make? And a lot of times, they can't. So it's not always the right move. You don't want to just willy-nilly just say, okay, we're going to cooperate. It really needs to be a thoughtful and strategic process.
So to that end, the example that you used earlier, using a lower level, so employee who did something wrong, how often is it that a lower level employee does something and that it rises to the level of the SEC, but honestly, the people at the upper level weren't aware? I could see how that happens, but I wouldn't say that that's a common occurrence, but I can see how often does that happen?
Yeah, I mean, I think it happens. It happens a lot. I wouldn't say one, that they either knew or didn't know is more common than the other. I mean, the bigger the company it is, the more diffuse. I'll give Volkswagen as an example, even though we charged when I was at the SEC, we charged the CEO, Martin Winterkorn, of being involved, and we alleged that other senior people knew and kind of what was going on. But here you go. You've got a huge company, a massive international company, and we're alleging securities fraud. And the securities documents that we were using to state our case, that we said were misstated and misleading people, were prepared in all different aspects of, offices all around kind of Volkswagen, and some in Germany. There was work done in the United States on these documents. And so it's really trying to connect up the false statements in the documents with people that were working on them that knew that those documents had included those false statements. And so, I think for Volkswagen's defense was, look, the CEO of Volkswagen, with tens of thousands of employees and billions of dollars in revenue, he's not focusing on, bond offering documents. He doesn't know what's in these documents. And we obviously disagreed with that in that case. But in a lot of cases, with large corporations, that's plausible. It's plausible that the CEO or senior officers who are in charge of running the overall company are not involved and aren't aware of kind of what is happening in some, bond preparation or securities offering documents that are being prepared in New York, so to speak. So it happens. The smaller the company, the less plausible I think that becomes. But that it's not unheard of.
But you guys were successful in prosecuting that specific case.
Yeah,
So
it
how did
ultimately
you link that up?
it was ultimately settled. It was it was the investigation really did it. It took a long time to investigate that, to get information from Volkswagen and other parties, including emails, a lot of e-discovery, where we could. A lot of testimonies. The investigative team, took testimonies in foreign countries of Volkswagen employees. It really took, almost 2 years of investigative effort, almost full-time investigative effort, to gather the evidence needed for us to make those allegations. So we thought we could prove up that not only were the statements in the documents themselves untrue or misleading or false, but that the top echelon of Volkswagen knew about it. And that Right. was a credit to the investigative team, Kevin Wisniewski, Jake Schmidt, and others who worked on it. They put their heart and soul into it. And actually, Zane,
Okay.
I just as an anecdote, you can see this. It's really called a carrion hawk behind me, but when we brought the case, we were later. The SEC was later than the other federal agencies that had sued Volkswagen out of this emissions scandal, and so by the time we brought our case, Volkswagen was already being sued by the FTC and DOJ, EPA, and others, and settling with them. And we brought our case, and the Judge Breyer, was not real pleased. And so my first court appearance, he was upset that the SEC came in as he thought it was late. And he said, "What are you? A bunch of, you're not supposed to be a bunch of carrion hawks picking up, pulling meat off the carcass." And so I didn't know what a carrion hawk was, frankly, at the time. So I had to go back and look it up. And it's essentially a vulture. And he said, "Why didn't you get in here when all these other federal agencies were in here?" And to your point, or to the point I was trying to make, was because our case took longer to build. Ours was a securities fraud case. It wasn't emissions. It wasn't basically you lied about your emissions from your cars and you got caught, which is what the other cases were generally about. That was part of it, but we had to show that those, there was misstatements in securities documents, investment documents that were presented to investors, and that people back in Germany knew about it, and that's really what took a long time. So when I left the SEC, my colleagues in the trial unit got me this picture of this carrion hawk because because of Judge Breyer's comments at that first hearing.
So if a company could only do one thing right now to reduce its SEC risk, what would that be?
If they could do one thing right now to reduce their SEC risk,
Yeah.
It's a good question. Consult a lawyer about just compliance issues. Really, they need to know their space they're in and where they've got SEC exposure. Not every company really has SEC exposure, but the companies that do, public companies that are have got accounting issues and SEC filings and that sort of thing, is really make sure your internal controls are in place, that you've got the proper processes and procedures in place to stop and try to catch the mistakes and bad conduct. You can't stop everything. You're never going to be able to prevent all types of fraud. But if you've got good processes and controls in place, one, you're going to catch a lot of it and you're going to stop it. And two, if and when the SEC does come knocking on your door, if they feel like you've done what you can do and what is reasonable for a company like you to do to avoid, kind of these, securities violations, you're much more likely to get off with either no charges or a slap on the wrist. And the other thing is it's tone at the top. I think that all starts from tone at the top. The CEO, the people in charge of the company really need to make sure that everybody else understands that compliance with the law is paramount. That it's important. People need to do it. And the company's not going to look the other way when people are cutting corners.
So a lot of executives assume that if they haven't done anything intentionally wrong, the SEC will figure that out and just go away. Is that actually how it works?
No. I wish it was how it worked, but it's not. It's not how it works. In fact, the SEC brings a lot of charges. It can bring a lot of charges where intent is not required. Some of the charges they can bring are what they call strict liability charges. So they can bring a charge and have brought charges against individuals and companies that engage in conduct that they with the best intentions. They even may have consulted a lawyer about it, thought what they were doing was correct, and it turns out that they were violating the law, not intentionally, with good heart, good faith, good mind, and the SEC says, you know what, still a violation, and we're going to charge you for it. That's less likely to happen under the current administration. More likely to, and did happen a lot under the prior administration, but the SEC can bring plenty and does bring plenty of charges that do not require intent.
So there's also a belief amongst a group of executives that the best strategy is to fight everything, give the SEC as little as possible, obstruct, block in any way they can. How would you advise a client who says that's what we want to do?
Yeah, no, I've never seen it work. Making the SEC work and do their job and to fight them, absolutely. There's a time and a place for it, and they shouldn't have any easier path than anybody else in proving their case. But as a matter of just standard practice to obstruct and deny and deflect and try to be as difficult as possible, it doesn't work. These are smart people. Most of the lawyers now in the enforcement program and other programs, the exams program, they came from big firms. They've got top-notch legal educations, come from the best schools. They're just good lawyers and good accountants. They've got really good examiners, they got experts in the industry. So if you think that you're just going to outsmart them and tell them to buzz off, generally bad, bad advice. Not going to happen. But you should, you know, when it's time to fight, you fight. And look, they get it wrong. They get it wrong. The SEC doesn't always get it right. No government agency always gets it right. And when they get it wrong, you tell them they get it wrong. And if they're, if your client's position strategically and legally is better off fighting and putting them to their paces, then that's what you should do. But it's not always the case. I always thought, Zane, that the most effective ones when I was on the other side came in and were realistic with you, honestly, both about the strengths of the SEC's case as well as the weaknesses. And so you knew that they understood the case. And I always thought those were the most effective advocates. But there's definitely a time and a place to fight. I mean, and I think people have been more successful lately doing it, and that's probably a good thing because the SEC does need to know that we better have our case shored up and our facts shored up before we bring a suit against somebody, rather than think that we can just bring this case and they'll settle with us because they don't have the wherewithal or the will to fight the SEC. That's the wrong strategy too.
So let me ask you a little bit about Venable with that. So this gets, these are more difficult conversations because I know you have, you can't discuss any individual clients, obviously, but typically when you're called into, these are all public corporations. When you're called in, at what point do you get called in? Are you called in before things happen? Or after they happen, or you called in to set things up in the organization to make sure that we're not screwing the pooch, so to speak? Or at what point does Venable come in and help?
It really runs the gamut, Zane. We've been brought in early on when people are maybe there's a new SEC rule that's been passed that the company's got to comply with. And so the cybersecurity rules were one of those, instances when the SEC passed a bunch of cybersecurity rules years ago. Companies were like, how do we comply? And so you want experienced people, and Venable certainly has experienced lawyers on the front end to kind of come in and say, okay, here's what the rule means. Here's how we interpret it. Here's why we think we can best set you up so that you don't violate it and you're complying with it. We get brought in, when a subpoena, the SEC sends a subpoena, kind of like how we started. It says, Dan or whomever, help me understand, why did we get the subpoena? Are we in trouble? What does it mean? That sort of thing. And I've been brought in, I work on matters where, the case has already gone on. The SEC has already sued, and the client has been defending with other lawyers against the SEC, and now they want, maybe they want a second opinion, or they want to know, somebody with more detailed knowledge of kind of the inner workings of the SEC and how to achieve the best settlement possible with the agency, and so we get brought in. It's never too early or too late, to be honest with you.
Mm-hmm. So, is Venable as a firm? Are they, Dan? What other areas of specialty, or are you strictly working with public companies on securities law?
No, I mean, Venable does a whole broad range of stuff. Anything. We've got private wealth, practice. I do a commercial litigation practice. We got corporate lawyers, IP lawyers, really kind of to run the gamut of legal services that companies and individuals might be involved in. We don't do any personal injury work or anything like that. But I split about 50% of my time between commercial litigation, business litigation, that has nothing to do with the SEC. It's just basically companies suing companies or that sort of thing. And then the other half of my time is really on the government investigation side, whether it's the SEC, the CFTC, assisting on some DOJ matters. We have a white collar kind of criminal group as well that I work closely with. So it really kind of it's really diverse.
So, Dan, if somebody's been listening today and they have questions or would like to get in touch with you, what's the best way to do that?
The best way is to shoot me an email, djhayes, Hayes, at venable.com, or just call me up, 312-820-3434. Glad to talk. I mean, I spend a lot of time just talking to people about issues, and without them ever actually becoming, formally clients or that sort of thing. So I think the best, don't worry, about reaching out, just reach out.
Thanks, Dan. Thanks for coming on the show.
Zane, thank you. I appreciate it. Thanks for having me here. I enjoyed it.